All rise. The Court of Appeals Division 1 is now in session.
Please be seated. We're here in our case 1CA CV15 0708 BNCCORP versus HUB. Side will have 20 minutes to present their arguments. But appellant, you may reserve any time that you want for rebuttal, but you'll have to keep track of the time yourself. We have a clock at the podium so that you may do that. We are recording the argument, and in a few days you can watch it on YouTube. Because we're recording it, please identify your client and yourself when you come up to argue so that we can keep everything straight. We've read the briefs, reviewed the record, and we've conferenced the case, so we're familiar with the facts and the argument. So when you begin your argument, just launch right into what you would like for us to know. Counsel, you may begin.
May it please the court. My name is Fred Bellamy from the law firm of Riley, Carlick, and Applewhite, and I'm here representing BNC National Bank, one of the plaintiff appellants here. I'm joined by Richard Osland, who served as lead trial counsel and also serves as counsel for both the bank and BNCCORP, a holding company. I will address the issue of the jury waiver, and Mr. Osland will address the issues relating to duty, causation, and damages. I want to start by pointing out, as we all know, the right to a trial by jury in a civil case is guaranteed by both the U.S. Constitution and the Arizona Constitution. The Arizona Constitution calls the right inviolate. It is subject to waiver as prescribed by law, but where there is not a waiver, as there is not here, then there is no discretion to deny a trial by jury. The bank did not enter into a waiver of its right to a trial by jury, and therefore reversal is required, a new trial is required. It is true that the waiver of the right to a trial by jury itself is not subject to heightened scrutiny, but the existence of that waiver in the first instance is subject to narrow construction, narrow interpretation. There is a presumption in favor of honoring the right to a trial by jury. The bank did not enter into any jury waiver, and the record makes that clear. I want to address the specific agreement that contains the jury waiver, to which the bank was not a party. But first I want to lay out...
The bank is a subsidiary of BNCCORP?
Yes, Your Honor. It is a subsidiary, but under ordinary principles of contract law, as well as the law relating to jury waivers and other such things, a subsidiary may, by mere existence of its relationship to the parent corporation or the holding company, is not a party to the contract.
If BNC had decided in its corporate judgment that waiver served the interests of the corporation, the bank would have waived it, correct? I mean, BNC had the authority to waive it for the bank if it chose to do so, correct?
if you're asking if the holding company would have had the sheer Roth power to order the bank to do so, presumably so, but the directors of the bank itself have their own duty when they're wearing their bank director hats to make decisions in the best interest of the bank. But in any event, Your Honor, the important fact here is that the asset purchase agreement that contains a jury waiver does not contain BNC National Bank as a party. It is not a signatory. It is not a third-party beneficiary. In fact, the contract itself expressly disclaims that there are any third-party beneficiaries.
Counsel, there are a number of cases involving agreements to arbitrate that find those agreements binding on non-signatories, correct?
That is correct, Your Honor. And one of the things that I want to address to this court, and because the case law is, there is a tension between these arbitration clause cases and the jury waiver cases, but context is important. And the cases are actually consistent when you carefully examine them. In the case of an arbitration clause, you have both the Federal Arbitration Act and the revised Uniform Arbitration Act under state law that both create presumptions in favor of arbitration, and there's the public policy behind it. So, of course, incidental to the enforcing an arbitration clause, the right to a jury trial is waived. But that is an entirely different context from an express jury waiver. And those cases are consistent. If you look at the case law in the federal courts that have addressed express jury waiver contracts as opposed to arbitration, they've recognized this tension, but they've said that the jury waiver, standing alone, independent of an arbitration clause, has exactly the opposite presumption as the arbitration clause does.
But doesn't a party who gives up, who agrees to arbitrate, give up more in terms of judicial protection than a person who just agrees to waive a jury and have a judge determine this case? That is to say, you agree to arbitrate, you're giving up the protection of the whole judicial system.
That is true, Your Honor, but again, there is a public policy in favor of arbitration that necessitates, waiving the jury. There is no such public policy, and U.S. Supreme Court and federal authority, including Ninth Circuit authority addressing Arizona law, has found the opposite presumption when interpreting a contract that includes a jury waiver as opposed to an arbitration.
And where would that decision be found?
They're addressed at the beginning of our argument in our opening brief, Your Honor. The context is important. An express jury waiver under the case law must contain the signature, the assent of the party that's waiving, with two exceptions that are arguably pertinent here. The first is a third-party beneficiary exception. As I've already noted, the bank is not a third-party beneficiary. It is expressly disclaimed as a third-party beneficiary. There is one indemnity that's expired that's not at issue here, in which the bank may have some rights, but it is not a third-party beneficiary. It has no ability to enforce this contract. And HUB relies heavily on the Harlan-Clark case, which it calls highly illustrative because it picks out similar language from the asset purchase agreement in that case to this case. But a careful examination of the Harlan-Clark case shows that those facts are highly dissimilar and completely distinguishing. For example, in the Harlan-Clark case, which dealt with a parent corporation as opposed to a subsidiary being the non-signatory, the asset purchase agreement in that case expressly declared that Harlan-Clark, despite not being a party to the contract, had the authority to enforce the entirety of the contract. Clearly, the third-party beneficiary, exception applied there. And by the way, this case was neither an arbitration case nor a jury waiver case. It's a foreign selection clause case. HUB relies on the fact that in that case you had a similar phrase, that the foreign selection clause applied to claims arising out of contract or relating to, and any transactions contemplated by that asset purchase agreement. But the court itself, in a parenthetical, read transactions contemplated by the asset purchase agreement. It put in parentheses the acquisition of the assets themselves. That's not the case here. This case, these claims, the bank's claims, have nothing whatsoever to do with any of the obligations, rights, benefits under the asset purchase agreement at issue here. The second exception on the jury waiver issue is direct benefit estoppel. And illustrative of that is the Arizona case in which a passenger brings a lawsuit against the driver's insurer, a claim that has no basis directly against the insurer, given the lack of privity, except for the assertion of benefits under that contract. That's the instance in which an arbitration clause may be invoked, and the party may be stopped to deny the waiver. But that's not the case here. Neither exception applies. Unless your honors have any question about the jury issue, I'm going to turn this over to Mr. Osland.
I'm going to do my level best to keep about 5 minutes for rebuttal, but we'll see how it goes. May it please the court, I'm Rich Osland. I represent BNCCORP. I want to take, and I want to say I really appreciate the fact, or we appreciate the fact that the court has reviewed the matter, gone through the briefing in detail, because I have endeavored to put my comments into three buckets. So as you think about this case and how it fits within the landscape of all the appeals you see in Arizona law, that you have a sense of at least our respected suggestion on how to take a look at this one. So number one, there is a series of issues, a cluster of issues that all surround the fact that in this case, the trial judge did not follow established Arizona substantive law as expressed not only in your courts, but in your legislative decisions over a consistent period of time. And this is on issues that go fundamentally to the heart of this professional negligence claim. The existence of the duty, the standard of care, causation, affirmative defenses, reversing the burden of proof, holding against an insured, the fact that they settled in a way to try to reduce the issues that are out in dispute. All of those are significant issues throughout the body of this decision. And with the time I have, I'll come back to those, but I want to get to my second point to say the second thing I want to have focus on, the second basket, is the fact that we're talking about errors that are substantial and material. Now, you know from our briefing that what we have here was a case that was before Judge Reyes for 2 years, right to the end of discovery, and shortly before trial, he went to the federal bench, and we had Judge Bustamante come on the case as the new judge to handle dispositive motions and trial. And the order that we're appealing from, the findings, conclusion, and order, adopted 100% without any changes of all of the findings and conclusions prepared by HUB. Now, that's significant not just for the fact that it is the Ninth Circuit has said that you raise higher scrutiny when that's the case, but it's significant when we talk about looking in depth into the record and whether or not that order really tracks the evidence at trial here. The third thing I want to try to get to in the time I have is more of a pragmatic judicial administration. Where do we go from here? How do we fix this suggested approach on dealing with the material errors and the reversible errors below? Quickly then on substantive law. In this case, you're very familiar, I know all of you, with Darner and Southwest Auto and their progeny. In this case, when you study the judge's findings and conclusions, what you will see are the following things. A standard that is not Arizona law, but rather a broker, a professional broker, in this case HUB, a $4 billion a year revenue company, in fact being put under the lens of a mere order taker standard in terms of a broker. The second thing we have is that here, in terms of expert testimony on standard of care, we had Mr. Hogan, who testified on standard of care, Mr. Emmett, and significantly, Mr. Sopizio, a 40-year veteran of Marsh McLennan, the largest brokerage firm in the world. And Judge Reyes, in response to a motion to exclude two of our experts said, no, you have two theories here. You have a theory as to what Brett Plant, the single broker in Trinidad, Colorado, who was assigned to this, did wrong. And you've got corporate wrongdoing and negligence, failure to train, failure to supervise, failure to assign to your specialty insurance group in Texas when it came to the need to have a new broker for BNC. And Sulpizio was specifically permitted to testify on that point. HUB had no responsive expert. The judge's order doesn't address it at all. Doesn't address the separate corporate liability and negligence that causally led to the fact that an incompetent, for purposes of this word, and I'm not trying to be offensive to Mr. Brett Plant, he didn't even call him to testify at the trial. We had to do it by deposition. But the fact is, he himself said, I don't know anything about basically this area of the law, or this area of insurance. I don't have experience with these kind of banks. I don't know why HUB assigned me. I wasn't aware of the specialty services. I wasn't aware of any of the things that were even in the applications, despite the fact that it was HUB's suggestion that this be remarketed. Remarketed meaning you go to the market in 2008, a critical time in the banking industry when we have the meltdowns, and they are seeking new coverages for 3 years. And this is undisputed evidence in the record that this is what the request was. It's confirmed in writing. And then when Mr. Plant comes to the BNC board in the middle of August and recommends that we change carrier, go to Colonial and Travelers, which the board accepts his advice, just as consistent with your standard here in Arizona, he was engaged to provide professional advice. He provided, they trusted him and relied on it. They then had to fill out the forms, the applications for Colonial and Travelers. And there were 2 blanks there in those having to do with servicing contractor coverage. And because BNC wanted to make sure it was filling out correctly, that we have in the record here, September 4, 2008, 42-minute telephone conversation, because we have the length of the period of time where BNC's CFO and Annette Eckroth, who worked with Mr. Plant, discussed specifically servicing contractor coverage, $15 million, and the program that it was needed for. And Brett Plant assured them that they had it. He had them fill it out, and the record is that he didn't know anything about it. He didn't go to the carriers to discuss it. He didn't advise BNC that I don't know if they have coverage or not. You need to talk to someone who knows. And under Darner, and interestingly enough, even under the standard that they came to court, this Nelson standard from Wisconsin that's been specifically rejected by your courts, even under that is testified to by their single expert, Mr. Alberts, who said, well, an agent, when asked a question on coverage, needs to answer truthfully. He or she needs to say, I tell you the answer, or I don't know the answer. That's admission in this record. The record below is that Mr. Plant failed to do what even their expert on this mere order taker standard was saying is the requirement. So in this case, we then go from the fact, and it seems with respect that whether the trial judge was confused, or whether, having decided this threshold issue of duty and standard of care, just kind of maybe ran the table on the rest of the things and didn't carefully think about it. Here's examples. On causation, what basically the judge has said is that BNC had to prove exactly that an exact policy covering this exact program was available in the marketplace. That's not Arizona law. The fact is that we've briefed this, and the fact is that Hogan, Emmett, and fact witness, the prior broker on this matter, Kathy Cook, all said that in 2008 there were multiple ways to secure coverage for this MLT program, for which BNC eventually lost $27 million. Undisputed. No expert testimony, no fact testimony from HUB contrary to that. Yet the judge in the ruling says that BNC had to come and prove that there was such a policy. Both the circuits and the states are somewhat divided. Some see it as an affirmative defense, where the burden would be on, in this instance, HUB to come forward with evidence that it wasn't available. They didn't. No fact witnesses, no experts. Some put it on the plaintiff to come forward and find that there are alternatives, reasonable alternatives out there in the marketplace at the time. It's exactly what BNC did with three experts and a fact witness. On the issue of affirmative defenses, the judge concluded an additional kind of related causation issue that BNC had to prove that, in fact, there was no coverage in the Colonial and Travelers bonds. HUB didn't offer any expert testimony. They had no fact testimony on that. There's absolutely nothing in the record to support that. The judge interpreted the policies herself. That issue wasn't tried. Under Third Eye Blind, which is a very instructive California appeals case that I would recommend the court to, it talks about, no, if you need to settle with a carrier because there are colorable defenses that in this instance cost BNC almost $4 million fighting with two big carriers for 2.5 years in front of Judge Wake, that in that setting, that is in effect no coverage when it comes to the issue of a broker. The existence of colorable defenses that prevented you from getting coverage in a timely fashion is evidence of neglect and causation. I know my time is running out here, so I'll be very brief in concluding. On the pragmatic standpoint, we talked about the jury trial. We support that. We join in it. The question is, a jury trial on what? What I mentioned to you is that we've got this, when you take a hard look at the actual record, this was a tightly, thoroughly, and directly litigated case. The judge's findings and conclusions on top of it, all drafted by HUB, bear no fair relationship to the evidence that's actually there. What should be done here with respect is that we be reversed on liability and remanded. Reversed and judgment entered in front of BNC. When you look at this record on every one of these tests and standards, even under their own single expert, BNC should be awarded a verdict of liability. And what we have on remand then is the question of damages that the judge didn't reach but needs to be addressed by the jury. Thank you.
Thank you, counsel. Counsel?
Good morning, Your Honors. May it please the Court. David Garner of Osborne Maladon on behalf of the Appellees HUB, and with me at counsel's table is client representative in-house counsel Bob Knowles. I'd like to jump into the jury waiver issue, and there's actually 2 points there I think that are relevant for purposes of the appeal. One is the applicability of the waiver to the bank, and the second is the scope of the waiver. As to the applicability to the bank, it's not entirely accurate to say that the bank is not a signatory. In fact, the purchase agreement itself in sections 4.5 requires certain consents to be issued and to be signed off on as a condition of the agreement being executed. And among those consents are lease assignments and lease agreements, which in fact BNC National Bank is a party to and a signatory to. And those are important. They're included, and they were included in the trial court record, and were included as exhibits to the purchase and sale agreement. And the lease assignments have specific language that say they are, quote, in furtherance of and subject to the terms and conditions of the purchase agreement. And that was signed by Greg Cleveland as the president of BNC National Bank, who's also the same person who signed the purchase agreement on behalf of BNCCORP. In addition, we have, the lease assignments were signed by Tim Franz, the CFO. The 2 lease agreements, which are also a part and exhibits to the purchase and sale agreement, expressly acknowledge and, quote, agree that the purchase agreement and this lease constitute the sole agreements between the parties. And so you have 2 documents that were signed and executed by the bank that expressly incorporate the terms and conditions of the purchase agreement and are actually saying that we agree that the purchase agreement constitutes an agreement between us and a HUB entity. And so that's why, in addition to the points of a third-party beneficiary and the direct benefit estoppel, this jury waiver is applicable. Now, again, in the agreement itself, it says in section 1.3 that the schedules referred to herein shall be an integral part of this agreement to the same extent as if they were set forth verbatim herein. So those schedules and the agreements that came out of them were incorporated into the agreement. Beyond that, as we've indicated and discussed in our briefing, there are other avenues legally by which a non-party is sometimes held bound to the terms and conditions of the agreement. One of those is a third-party beneficiary. And we've noted in our briefing, I'm sure your honors have read, that there is a point that says we don't have any third-party beneficiaries except. And that exception is important because it expressly includes BNC National Bank. The exception is with respect to the seller indemnified parties, and BNC National Bank is expressly a seller indemnified parties because it includes affiliates of BNCCORP. So it is a third-party beneficiary. The fact that that indemnity provision was an 18-month provision doesn't have any impact on the applicability of the agreement to the bank any more than if we're having a discussion about whether consideration is sufficient. They were a third-party beneficiary, was expressly recognized in the agreement itself, and under those circumstances we cited several cases in our briefing that indicate that a third-party beneficiary can be bound, including Jeans versus Arrow, Altera, and the Williston case. In addition, there's a direct benefits estoppel theory. Here, in addition to the lease agreements that were signed, that were a benefit to BNC National Bank, and the lease assignments, all of which gave them approximately $150,000 per year in lease revenue. They also received, as a benefit of the agreement, commercially reasonable brokerage services. And there's no question that that was a direct result of the purchase and sale agreement. So again, under direct benefits estoppel, BNC Bank would be covered by the jury waiver. The second point, beyond the applicability of the bank, is the scope of the waiver. The language that is used in this waiver has been identified in the courts as being extremely broad, quoting from the Harlan Clark case. And the fact that that is a forum selection clause versus a jury waiver clause is not material for purposes of our discussion. But the language is arising out of or related to not just this agreement, but any of the transactions contemplated by thereby. And certainly a transaction contemplated thereby was that HUB would provide brokerage services to BNC National Bank, which in fact it did. And the Harlan Clark and other cases we've cited indicate that that type of broad language can encompass all disputes between the parties, regardless of label. It reaches all aspects of the relationship, and even in the Harlan Clark case did not necessarily include a contract claim. It include tort claims, and they rejected the argument that claims not based on contract and not seeking to recover under the terms of the contract would still be encompassed within that broad language. And finally, Harlan Clark indicated a point that I think is relevant as a matter of fundamental fairness. The point that was made in that case is that the parent company and the subsidiary was asserting identical claims. They didn't allege that they suffered any independent injury, and the ruling was they shouldn't be allowed to circumvent a jury waiver by naming a non-signatory party. Here, the same considerations would apply. There really isn't any question that the jury waiver applies to BNCCORP, and so they would not be entitled to a trial on remand. And so you have, if you were to remand for the bank, you'd have the possibility of inconsistent verdicts, which goes to the fundamental fairness point that Harlan Clark indicates. I'd like to turn now, Your Honor, to the components of the negligence claim. First, to the duty and standard of care. The trial court properly recognized that a duty is imposed by virtue of the broker relationship, and I want to make that clear. We don't argue that you need to have some special heightened standard in order to have a duty applied. It's clear from the Darner case and the Southwest Auto Body case that a duty exists. And really what we're talking about and what the trial court grappled with at the trial court level is what's the appropriate standard of care. The duty is to exercise the degree of care, skill, and diligence normally exercised by similarly situated insurance brokers. And the question is, what is that? And that's where we need to look into it as a fact issue. Well, there's several things that the court looked at and could consider in determining what that standard is. One, obviously, is expert testimony. There's no question that we had several experts testify about what an appropriate standard of care would be at the trial court level. One of them was HUB's expert, Mr. John Alberts. BNC makes a point of saying, well, the trial court ruling doesn't ever say Mr. Alberts' name. Well, there's not any requirement that that be the case. If you look through the substance of the trial court's ruling and you compare it to the testimony of Mr. Alberts, you'll see that although he's not mentioned by name, the components of his testimony and of his opinion are expressed throughout the decision. Those points were that a standard of care is satisfied if the broker acts on the instructions of the client, obtains quotes for requested coverages from responsive carriers, presents the responsive quotes to the client, and then facilitates an exchange of information between the client and the carriers when there is a claim. And Mr. Alberts testified that in this case, HUB's broker, Mr. Plant and Mr. Thomas, satisfied that standard. Now, in addition to expert testimony, it's not solely determined by expert testimony. Standard of care can take into other issues because it's a question of fact. One is the court could take into account the distinctions between a broker and a risk manager. And BNC's expert on standard of care happened to be a risk manager and not a broker. He, in fact, testified that the services that he provides, which are specifically identifying risks for his clients and working with them, are separate and independent from the services that a broker provides. And, in fact, a risk manager is paid, and Mr. Emmett is paid separately from the payment that a broker receives in connection with the services that the broker provides. Another fact that the court could and did take into account in determining what the appropriate standard of care is were the informed decisions of published treatises and other case law that were consistent with Mr. Albert's opinion. The court also was appropriate to consider the standard of care that BNC applied to itself when it brokered its own insurance. And when you look at the record on that, it's very clear that Kathy Cook was their broker. They thought she was great. They had no qualms with her services. And in fact, after they left HUB, they went back to Kathy Cook at a different company. And yet, Kathy Cook got the very same type of coverage for the very same MLT program in 2005 and 2006 as an employee of BNC Insurance Services that HUB got for BNC in 2008. Ms. Cook didn't seek any manuscripted writer or special endorsement, didn't otherwise go in and scrutinize the whole bank and turn it upside down and figure out whether there's any potential far-fetched insurance coverage that could be applied. And that's important. That's certainly an appropriate consideration for the court to take into account in determining standard of care. In addition to that, the court could take into account the fact that the bank has certain non-delegable risk management obligations that are imposed upon it by the OCC, its regulators. And we've quoted those in the brief itself. Those are things that the bank has an obligation to do. It can be informed also, the standard of care, by the course of conduct between the parties. The record was very clear that BNC didn't rely on its broker to discover risks and address them. In fact, the record was replete with instances in which BNC, when it had a question or an issue, would raise it with the broker and ask them to consider coverage. In fact, the whole servicing contractor coverage wasn't a result of Kathy Cook looking into BNC's work or its business. It was brought to the broker's attention by the CFO of BNC. Now, beyond those practical and those issues of fact that the court could take into account, the standard of care that HUB propounded and proposed at the trial court level and that the trial court ultimately adopted is consistent with common sense. BNC knows its business. BNC is an expert in the bank's business, not the broker. And we have a situation here where the risk, the loss that was at play was one that BNC never recognized. Its lawyers didn't see it coming. Their senior management didn't see it coming. None of the internal auditors, external auditors, regulators saw this coming. And yet, BNC wanted to stand before the trial court and say, wow, HUB should have seen this coming. It doesn't make sense. And finally, I won't go into detail on that. It's in our briefing, Your Honors, but there's also a sound policy basis for not adopting the standard of care that was advanced by BNC at trial, and that is, it basically sets up a scenario where an insured has a perverse incentive to hide from its broker information because, especially on situations like this one where coverage is at best questionable, to put the broker in a position where the broker has to be kind of a guarantor. If we don't get coverage, that's okay. We can go sue the broker and claim that the broker should have gotten it for us. Okay. There is no standard like that that's been adopted in Arizona. It doesn't make sense. And even in the cases that they cite, like the Third Eye Blind case, all of those cases, the coverage at issue was off-the-shelf coverage. It wasn't this highly specialized, unique circumstance, go out to Lloyd of London and manuscript a special policy. That's not the kind of thing that any of those cases we're talking about. There's no authority to support that kind of approach. In terms of what HUB actually did, the record's pretty clear. They assigned a producer with experience to take over the file. He obtained quotes consistent with BNC's instructions from multiple insurers. He met with BNC's management, presented the options. He obtained the servicing contractor coverage that they actually asked for from a reputable insurer when others wouldn't offer it. He obtained a 50% increase in policy limits and did all of that at an annualized premium that was almost 20% lower than what BNC was paying before. There was plenty of evidence in the record to support the trial court's conclusion that HUB satisfied the standard of care in this case. Turning, Your Honors, to causation. The loss in this case was caused by the insurance carriers wrongly denying coverage at a minimum. The court ruled that there was coverage on the plain language of the agreement. There's nothing to prevent the trial court from reaching that conclusion in this case. Judges do it all the time. Look at the plain language of the agreement, look at the evidence that's presented, and apply them. And there was evidence presented. There was a testimony of BNC about AMS's servicing contractor duties. That was on the record in the case, perfectly available for the court to rely upon in reaching its conclusions. And that testimony matched up very well with how the servicing contractor coverage was described in the policy and what, in fact, AMS was doing for BNC. It was also supported by the various experts the BNC had relied upon in the underlying coverage litigation. Now, there was no contrary expert testimony provided at trial, and that's the interesting thing, that there wasn't any evidence presented on BNC's side to say, hey, there is no coverage here. They didn't put up an expert that said, you know, there's not coverage and the plain language shouldn't be satisfied here. Second, Your Honor, in terms of causation, a second and independent reason why there's no causation in this case is that they failed to prove the availability of better commercially reasonable coverage. And there's certainly ample evidence in the record to support the judge's conclusion on that. It was not clearly erroneous. Neither Mr. Emmett nor Mr. Hogan could cite to any actually policy or endorsement or rider that would have covered the loss. It's not necessary that they have to do that. But I think it's certainly when the judge is weighing who do I believe here, be able to say, hey, where's the policy? What is the actual language that you suggest that Brett Plant and Jerry Thomas should have gone out and secured to cover this particular loss? Kathy Cook failed to obtain coverage when she became their broker again after they left HUB. And there wasn't any testimony of any actual underwriter at trial that says we would provide this. We had at best a hearsay comment from Kathy Cook that she talked to somebody who said they might have done that in the past but don't do it anymore. A third independent reason why causation was not established in this case is that it was not clearly erroneous for the court to conclude that BNC would not have or could not have obtained that mythical coverage if it had been fully transparent about the actual facts of the underlying program, including the fact that AMS, the party that it chose to do business with, was under a consent order and had been fined by the Arizona Department of Financial Institutions nearly $250,000 for unlawful conduct, including failure to manage its books and poor record-keeping practices. It was reasonable for the trial court to say you wouldn't have been able to get coverage for an AMS relationship when you are dealing with a party like that. And also, I think it was reasonable for the court to say you wouldn't have gotten coverage because you failed to include adequate and even basic, simple controls that would have prevented the fraud in the first place. You're letting AMS do whatever it wants with the money with no checks and balances. An underwriter wouldn't have applied that, and it was not clearly erroneous for the court to rule otherwise. And finally, Your Honors, BNC failed to provide adequate information to HUB. Even if their standard of care were somehow adopted, they have an obligation to bring that information to light to the broker. And the fact of the matter is they never did. You can go back and read in our briefing about the September phone call. It wasn't there. And it's undisputed. They never gave us a copy of the agreement. They never gave us a copy of the amendments to it. They never gave us a copy of any of their credit displays. They never gave us a copy of any of their any internal audits. And they never expressed a desire, concern, or any issue about the servicing contractor coverage that they'd already had for many years prior to coming into its relationship with BNC. Your Honors, the fact of the matter is the jury waiver is applicable to the bank as a third-party beneficiary or under the direct benefits estoppel doctrine or as a signatory to contracts that were incorporated and integral to the agreement itself. And the judge was not clearly erroneous in her rulings on standard of care or causation, and for that reason we'd ask you affirm the decision. Thank you.
Thank you, counsel. We appreciate your arguments today. We'll take the matter under advisement and we'll issue a decision in due course. We'll stand at recess until our next argument at 1:30. Thank you.